An enraged, blue-haired woman commands her dog to attack a store clerk, and we have the video to share with you. This one's crazy. Let's discuss how you could lawfully defend yourself against the dog, the owner, or both. Hey folks, I'm attorney Andrew Branca from Law of Self-Defense, and for those of you who stayed to the end, and I sure hope that's all of you, I'll share with you how you can join us for our 100% free upcoming Law of Self-Defense Hard to Convict class. I have a video of a confrontation to share with you that's pretty funny. Funny because it doesn't appear that anyone or any animals were harmed in the making of this video, but it raises some interesting legal questions about self-defense. The confrontation here takes place in a convenience store, and the video is a cell phone recording by a bystander customer. It appears that a blue-haired female customer is outraged that she's been suspected of stealing and has been ordered to leave the premises. Instead of being a normal person and complying, she decides to act like a crazy person and initiate a physical and verbal confrontation with several of the convenience store employees. The video begins with Aqua Woman struggling to open the convenience store door, and when she finally opens it, instead of just leaving, she calls for backup, her good friend Miguel. And Miguel shows up armed, not with a gun or a knife, but with a dog. With that context, let's watch the video.
Miguel, get over here now!
Good old Miguel.
Miguel!
I'm just filming for you guys' sake, that's all. I'm just trying to buy a sandwich. I'm filming.
Put your camera away. This guy's a piece of shit. Get him! Get him! Go get him!
Don't attack me, man! Don't fight me! What the are you doing? You're attacking the wrong guy, man.
She's stealing the cup. She's not a fun. She.
Candy's up there, you goof!
That's your dog, man.
Here it is again!
Come here, Charlie. Come here.
Kill you!
Okay, crazy stuff. Let's dive into the use of force law dynamics that would govern in this situation. I'm presuming here that the dog being used as a weapon is an unlawful use of force. There are, of course, circumstances in which it would be lawful to use a dog as a weapon in lawful self-defense, just as it can be lawful to use any weapon in self-defense. But for purposes of this show, the context is the dog as an unlawful use of force. And to be specific, I'm not merely talking about defending yourself against a person alone or a dog alone, but defending yourself against a dog that's being wielded as a weapon by a person. The person is present and ordering the dog to attack you. In one sense, this is conceptually no different than the person deploying any other projectile weapon against you, as if they were hurling a rock or throwing a knife or firing a bullet. The object they are projecting is a use of force attack upon you. In another sense, however, the dog, which is animate, is of a quite different nature than a rock or a knife or a bullet, which is inanimate. And essentially, the dog, once on a ballistic trajectory, has left the control of the attacker, the owner. Not only does a dog owner possess some control over the dog is also capable of its own decision-making. So in the dog as weapon context, we really have two attackers. One is the dog owner wielding the dog as a weapon, and the second is the dog itself. Which are you legally privileged to defend yourself against? In fact, you're allowed to defend against either or both for as long as you continue to be faced with an imminent threat of harm. The law does not require that you allow yourself to be bitten by the dog. You're privileged to defend yourself against an imminent dog bite, one that's about to occur. You needn't suffer so much as a nip before you are privileged to defend yourself against that dog. Your use of force in self-defense must, of course, be reasonably consistent with defending yourself against that attack. Turning and shooting an innocent bystander, say here the sandwich guy, for example, obviously could not be considered an act in defense against the dog. The legitimate targets for your use of defensive force would be either the owner or the dog. This can actually present an interesting tactical question. Which of those two targets, owner or dog, should be your priority for defensive force in order to neutralize the dog attack upon you. If you say shoot the owner, and we'll get to the issue of proportionality, whether a gun would be the appropriate defense in a moment, but if you were to shoot the owner, would that be likely to neutralize the dog as a threat, or would the dog simply redouble its efforts? Alternatively, if you shoot the dog, is the owner likely to concede the confrontation at that point, or is the owner likely to seek vengeance for you having shot his dog? I would suggest that it would be foolish to presume that neutralizing either the dog or the owner alone would be enough to secure safety from this dog as weapon form of attack. That doesn't mean you simply shoot both of them, but it means you need to be prepared for the possibility that shooting both of them will be required to secure your safety. As it happens, the legal rules of engagement for the owner and the dog are not at all the same, even though from your own perspective, the dilemma is essentially the same. You're simply acting in self-defense against each of them, but the conditions that have to be met and your privilege for using force against each are quite different. When it comes to the dog owner, you're contemplating use of force against another person, and that falls squarely into the standard law of self-defense and the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness, the 5 building blocks of any claim of self-defense. If you're not familiar with those 5 elements, by the way, then I urge you to pick up a free copy of our best-selling book, The Law of Self-Defense Principles, at lawofselfdefense.com/free book. This is your plain English handbook to how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. If you don't understand these 5 elements, you can't possibly understand the law when it allows you to defend yourself. Again, the book is free, except for the cost of shipping the book to you, and you can get it at lawofselfdefense.com/free book. So, with respect to the dog owner, we have the usual rules of self-defense, those 5 elements. You can use force against that person in order to neutralize a reasonably perceived imminent threat of unlawful bodily harm. You can use deadly force against that person if the threat they are presenting is deadly in nature. That is, it's threatening you with either death or serious bodily injury. In this context, of course, the threat is that of a dog ordered to attack you. Whether that threat qualifies as deadly, capable of inflicting death or serious bodily injury, will in part be a function of the size, power, and aggressiveness of the dog. For purposes of this discussion, let's assume the dog is large enough to inflict a bite wound that would qualify as serious bodily injury and therefore as a deadly force threat, and therefore licensing you to use deadly force in self-defense. If you presenting your concealed carry pistol and shooting the dog owner would reasonably be expected to neutralize the imminent unlawful deadly force threat he's presenting by ordering his dog to attack you, then shooting the dog owner would be a legitimate use of deadly force to neutralize that unlawful deadly force threat. That's true even if the dog owner isn't closing proximity or displaying a weapon, because the dog is the weapon and the dog is closing proximity. Of course, this privilege to use deadly force against the dog owner continues only so long as the dog attack is actually occurring or imminently about to occur. Should the dog run away, then it would no longer be an imminent threat, and you'd no longer be legally privileged to shoot the dog owner to neutralize a threat that's, well, no longer imminent. What about your legal privilege to use deadly force against the dog? Does that also need to satisfy the same self-defense law framework, the same 5 elements of self-defense? The answer is no. Self-defense law governs the conditions that must be met in order for you to justifiably use force against another person. If you're not using force against another person, then the lawfulness of your use of force does not have to meet the 5 elements required of self-defense. The question is no longer, were you reasonably perceiving an unlawful imminent threat of harm? Instead, the question is a balancing test. Is the harm being done by shooting the dog less than the harm that would occur if the dog were not shot? This balancing test is a very old and traditional legal doctrine, goes by a variety of names. Sometimes it's called the necessity defense, sometimes the doctrine of lesser evils, sometimes the choice of lesser harms. In essence, it justifies the commission of an act that would normally be unlawful. You're not allowed to simply walk around shooting people's dogs for no reason, for example. If that normally unlawful act is a harm substantially less than a harm that would have occurred had you not committed the normally unlawful act. A good analogy that reflects this doctrine might be if you saw a dog locked in a car on a hot day and in obvious distress and at risk of serious harm or death from overheating. You break the car window to save the dog. Normally, breaking the car window would be unlawful criminal mischief. You're not allowed to just go around breaking people's car windows, but it can be forgiven under the doctrine of necessity because the breaking of the car window is a lesser harm than would have occurred had you simply allowed the dog to die in the hot car. So with respect to the dog attacking you in our scenario, which we're presuming is presenting as a threat capable of causing serious bodily injury, a deadly force threat, the legal question with respect to the dog becomes, is the harm of shooting the dog less than the harm you're attempting to avoid, suffering serious bodily injury at the jaws of the dog? I think most people would say yes. Certainly I would. So the shooting of the dog would be legally excusable under the doctrine of necessity. Of course, as we noted earlier, if you shoot the dog, you might well find the dog owner now wishes to seek vengeance, perhaps John Wick levels of vengeance. Should that happen, we're now back to a traditional self-defense analysis to determine your legal privilege to use force in defense against the owner. A closing thought. Those of you who own dogs, at least in part for purposes of protecting yourself and your family, keep in mind that these are the same legal arguments that the person against whom your dog is directed will raise to justify their use of deadly force against you and your dog in response to that attack. All right, folks, I want to remind you all again that in a very short while, we're going to be holding our 100% free Law of Self-Defense Hard to Convict class. As the title suggests, this free class teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. This class is live streamed by me. It's not pre-recorded, and there's plenty of opportunity for live Q&A as well. It is 100% free. We don't charge for it, but we do limit the number of seats to allow adequate opportunity for Q&A with all the live attendees. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard-to-convict. I'll close out by reminding you all again that if you carry a gun for self-defense so you're hard to kill, or if you have a dog so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for lawofselfdefense.com. Stay safe.